Well, good morning, everybody. Thank you for being here on this part sunny, part rainy day, especially with school out and vacation starting. We know everybody is busy and balancing lots of different things, and we appreciate you being here. So Joanna Cooper with Nelson Galbreath is here today. Many of you have probably worked with her or talked to her before. She helps with the agent hotline that we have when you need an addendum written. She's the person on the other side bringing that all together. And she's here today to kind of talk to us about really the issues that can come up in the contract to close process from an attorney perspective. So we know that right now getting things under contract, if you have a buyer, is as hard as ever. And so we just want you to kind of know what some of these issues are, really to be as proactive as possible in the process so that you can get that contract to closing, because we know you've worked so hard to get that contract. So she's going to go through with us some of the common issues, give you really a greater depth of knowledge of those issues if they come up, and really some tips to help work through and find resolution. So on that note, I will hand it over to Joanna.
Thank you for that introduction, Amanda. I'm going to share my screen now. So we'll go ahead and jump right in. And today's presentation, and I spoke about this earlier with Amanda, we're going to give you a lot of information. So we'll open it up for questions at the end, but I'll also send this PowerPoint so you've got that for your reference. Just as a reminder, as we get started today, we've got our partnership with Title C. So Carrie is a wonderful asset and a great resource for you guys through the closing process, particularly when issues like we're going to talk about come up. So remember, we've got Carrie with Title C. So let's just go ahead and jump right in. So a lot of common closing issues are revealed through title work, and some of those we're going to know going into the closing. So perhaps you have clients that are going through a divorce or a loss in the family, but again, some may only be revealed through title work. And so to kick things off today, let's get started with just a brief overview of what title work actually means and what we are looking for. So generally speaking, title work includes the title abstract. So we are pulling back 40 years of deeds, mortgages, surveys, easements, restrictions, liens, foreclosures, you name it. And then we're going to examine that abstract. We'll talk about what we're looking for and some things that could pop up on our next slide here. Then we're going to identify and resolve the issues. So just to bear in mind, all of these issues that we're going to go through today can seem a little daunting, but all of these are solvable. So the best way to mitigate these issues is just to identify them as early as possible so that we can work on getting those cleared or getting what we need to get to the closing table. So we're going to give you tools on how to do that today. So what is the title examination? What are we looking for? So we're checking to make sure the chain of title is complete. We're not missing any deeds. Are there any issues with plats and surveys and legal descriptions? Have the taxes been paid on the property? Any outstanding liens, judgments, mortgages? Any deceased parties in the chain of title? Did the correct person sign the deed? Did they have the authority to do so? Has the property been through foreclosure? We'll pull all of those documents. A bankruptcy, divorce, any other lawsuits, tax deeds, you name it. So looking at all that big picture, what could possibly come up? Well, unfortunately, a lot. So let's just start by going through some of the common issues and how to solve those. So one of the most common things that come up, and this is a great example of something that may only be revealed by title work. Now, when we start our title work, we're going to go back and check every owner in the chain of title, including the new purchaser, back a certain period of time to determine if a lien attached to the property during that person's ownership. If a lien was filed against an owner while they owned the property, that lien attaches to the property and that will stay attached to the property, even if you convey the property or file a new deed. Most times, presumably the last closing attorney has cleared any prior liens, so typically we're just dealing with the current parties, but that's not always the case, unfortunately. Liens last different time periods. If it's a tax lien, those are only good for 10 years, judgments 10 years, and we could go down the list there. But our first step when these liens or judgments pop up is we need to identify, is this actually our person? Is this actually the owner of the property? Most oftentimes we can rule those liens out using a middle name, perhaps social security numbers or prior addresses, previous addresses. This is done during the closing process. If that person is not our client, which most often it is not, we'll sign an affidavit at closing stating, hey, that's not me, this judgment is not attached to me or my property, and we'll move on. If it is our person or our owner in the chain of title, it is attached to the property. So there is no getting around it. We have to receive a payoff or a release of that lien in order to get to the closing table. Now, depending on what party's involved or what type of lien it is, how old the lien is, obtaining a payoff can be a little more challenging in some cases. We also search buyers to make sure there are no liens or judgments against them. Now, why do we search that? Right now, it's not attached to the property, but once that buyer purchases the property, any judgments or liens they have against them will then attach to the property. Lenders are very interested in this information. They want to make sure that there are no competing claims or liens against their mortgage. Now, some of you, as you are sitting at the closing table, you may have noticed that these are coming up more often. Very recently, South Carolina compiled all of their tax liens on a state level rather than county level. So when we're searching John Smith, we're not just looking in Greenville County, we're looking in the state of South Carolina. So we're seeing more and more of these come up. So, it can be a little scary when someone reaches out to you and says, is this judgment yours? But just bear in mind that this is pretty common, particularly if you have a more common name. These will come up during the closing process. Again, if it's not our person, we can rule that out, move on. If it is, we've got to chase down at those payoffs or releases. Now, here's another really common situation that comes up during closing. The current owner is deceased. What do I need to do to get to the closing table? Our next slide will kind of talk about multiple owners, but generally speaking, if an owner has passed and they have a will in place, in order to get to the closing table, we're going to need a certificate of appointment, appointing a personal representative or a PR to the estate. And that will has got to give that PR the authority to sell the property. If the will does not explicitly state that, we're going to need the probate court to give us an order in order for the PR to sell the property. If the owner has passed without a will, we still need that certificate of appointment, but without the will, we'll need that court order from the probate court. So bear in mind, in any event, we have got to unfortunately go through the probate process to get to the closing table. That estate has to be opened. The personal representative would be the one to sign your contracts to. So this is great information to address prior to the title work if you can. Now, if the wrong person signed the contract, once we do that title work, we'll help you get the right people on the docs. But again, note in these instances that with one individual owner, the probate process has to be initiated in order to get to the closing table. Now, you may be asking to yourself, well, how does rights of survivorship fit in here? Now, if there were two or more owners of the property and one is deceased, what do we do then? Now, if the property was titled as joint tenants with rights of survivorship, so you've got two owners with that rights of survivorship, When one passes, the surviving owner has 100% ownership. You do not need to go through probate. This surviving owner has the authority to do whatever they would like with the property. We'll need a certified death certificate for the deceased prior to closing, but again, that will be requested during the closing process. If the property was titled as tenants in common, so they do not have that rights of survivorship in place, the interest of the decedent has to be probated through the probate court. So you may have a situation where an estate owns 50% of the property and an individual owns the other 50%. So that can get a bit complicated. Now, as you're sitting at the closing table, a great tip, particularly if you have, spouses, we default to that rights of survivorship so we can avoid that second scenario where we're going to the probate court. But that's a great question to bring up at the closing table to confirm that your clients have that in place. And, we're also happy to walk them through the different options and what these different deeds mean, on the other side of things. So another thing that we see come up from time to time is you get to the closing, or after we do the title work rather, and you see that there are covenants and restrictions on the property. Now, sometimes we're expecting those. You may have already read through them. It's pretty standard. It's what you were anticipating. But sometimes you may get a notification. Now, our office will send automatically any covenants and restrictions that are on the property. So sometimes when you receive that notification, you may think, I did not know there were restrictions on this property. Now, a common misconception, even if there is no active HOA on a property, there may be enforceable restrictions on the property. Check the verbiage of those restrictions. Enforceability looks a little different in those instances. You don't have an HOA company enforcing them. This looks like your neighbors taking a neighbor to court and enforcing it that way. A lot of times neighbors may not even know that those exist. Sometimes these old subdivisions with no active HOAs have restrictions from the 50s or 60s, but bear in mind that these are still enforceable. The covenants and restrictions themselves will lay out how to amend or modify those, which typically looks like a majority of the subdivision signing off, or perhaps all of them. Now, something to bear in mind to avoid any issues for this. The contract states that the buyer has had the opportunity to discover any restrictions on the property. So the mere existence of those restrictions on the property, even when you weren't expecting them, does not necessarily give you an out in the contract. So one tip to avoid any issues that could come up with this, particularly if you have clients that are trying to do something specific with the property. If they intend to subdivide the lot, perhaps they intend to build some sort of commercial building on the property, that kind of gets into other zoning issues. But if you have a client, or perhaps you know that they just do not want any type of restrictions, that's very important to them, and you will see that. If that's the case, you can always certainly reach out to us and we can pull those restrictions prior to signing of the contract, or you can put language in your contract making that a contingency for them to review and approve those, and we can help you with that. But just something to bear in mind. This is Topher. My husband and I have an ongoing rival of who can incorporate our animals the best in their PowerPoint. So if you see Chris Cooper, let him know that Topher has made the slides. Now here's one that may come up pretty often as well. We've got current owners or clients that are divorced or separated. What does that mean for closing? Now, as a practical tip on the back end of things before we get to the closing table, that is great information for the closing attorney to know so that we can, split up the process. We can send out separate information sheets, schedule separate signings. And if we've got a pending divorce and no final decree, what does that mean? We can get to the closing table, but at that point, the parties are going to have to authorize the proceeds split. If they have filed for divorce and they each have an attorney, we may be communicating with those attorneys to see if they've come to some sort of property agreement. If the divorce is finalized by decree, the proceeds have to be distributed per that decree from the court. So we're collecting all of those documents from the family court. Now, bear in mind that perhaps, wife has already quitclaimed her interest to the husband a long time ago, while they own the property together. Ex-husband's at closing, but our divorce decree says that ex-wife, who's not even on title, may be entitled to some of those proceeds. So it could include different parties, but we have got to look at those divorce documents to figure out who gets what. Now, here's another thing that could come up during closing, particularly during the title work. We're going to email you the current survey of record on the property. You've received that, and it's showing some type of encroachment or some type of easement that you weren't expecting. Don't panic. Encroachments can be fairly common. We see a lot of times we've got a fence that's a foot over the line onto the neighbor's property. A porch may be, just right into a sewer easement by about a foot or so. We're going to bring this to the attention of the parties prior to closing. Most often it is a non-issue. We can draw up encroachment agreements or walk the clients through what those encroachments mean for them practically, what that means for them title-wise. Otherwise, we may have some more pressing issues like a boundary line change, unclear meets and bounds. Perhaps a permanent structure is encroaching onto the neighbor's property. In some instances, we may require a new survey. But again, all of those types of issues will be addressed prior to closing. It may seem like a very major challenge at the time when you see these encroachments, and it certainly can be, but most of these are really quite common. And you may see the most current surveys from 1974 showing a chain link fence that's encroaching onto your property. Well, that fence may not even exist anymore. So reach out to us if you see these types of issues come up. We've got lots of options, but again, most times these won't hinder getting to the actual closing table. Now, another issue, I say, or just situation that will come up during closing is you've got a seller or perhaps a buyer that is an LLC or an entity. We are going to be asking that seller for a lot of information. We're going to need the organizational documents for the company. We'll need to know about their assets. We're going to ask them if the transfer at closing will entail a majority of their business assets. So you can kind of prep your clients to go ahead and start gathering that information. It's going to tell us who needs to sign at closing. Bear in mind that if the property being sold is a majority of the LLC's assets, we're going to need additional tax documents from the Department of Revenue. We need a tax certificate of compliance, which can take, up to 2 weeks to receive. So as a practical tip as well, particularly on the seller side of things, we're going to send out information sheets from the get-go, and it is really important that your client gets that information to us so that we can start collecting what we need so that, that tax compliance letter, while we approach the closing date, is a non-issue. We already have that in place. We pulled that, 2 days after the information sheet was sent. So again, LLCs, not an issue, but we're going to need more documentation in order to get us to the closing table. Another issue that you may come up is unexpected tax implications. Now, this could be a whole nother, 2-hour class, but if you have a seller that is a non-resident of South Carolina, or perhaps a non-US citizen or non-resident alien, there may be withholding required. And just to put this out there. Non-South Carolina residents, now there are exemptions that we can explore prior to closing. We're going to withhold 7% of the gain. Now, for a non-US citizen or a non-resident alien, that tax withholding is so significant. It's 15% of the purchase price withheld. I have seen a situation where we are at the closing table. Seller did not provide us with this information. It came up at closing. Their settlement statement changed from receiving about $15,000 to owing about $15,000. So if you have a non-resident or a non-US citizen, be sure to get that information to us from the get-go, one, so that we can explore any type of exemption that we can, or get the clients in the right hands with a tax expert. But the last thing we want is a surprise at the closing table that we're withholding 15% or 7% of their gain. Trusts. This comes up a lot too. If you've got a client that is holding their property in a trust, what does that mean for closing? We can get to the closing table, but we're going to need additional documentation. Now, the laws on this have changed fairly recently, so you may have some clients that have never had to do this before, but most title companies are requiring that we have a certificate of trust dated with at least a year of closing, within a year of closing. And we can walk them through what that looks like, what we need. We could also accept the full trust document. Most people don't want to share that for good reason. And we've got to ensure that the trust authorizes the trustee to sell the property. So again, we're going to need additional information to get to the closing table to make sure we've got the correct trustees and the trustee has the authority to sell the property. I'll bear in mind as well, the trustee is also who will be signing your contract and other closing documents. And so this can be great information to collect from the get-go. One of our title underwriters for a title insurance company once told me that the most issues he had title-wise were trust issues. So just kind of bear that in mind. If you do have someone holding property in a trust, again, no big deal. We can get it to the closing table. We're just going to have to pull some additional information. I've also incorporated my quarantine kitties here. The key on all of these issues or situations is just to identify them as early as possible. None of these are unsolvable, but the last thing you want is for one of these items to unexpectedly come up right before closing or even at the closing table. Again, all of this can be a non-issue, but they just have to be addressed as early as possible. So if you think, or even if you just have an unusual situation, just bring that to the attention of the closing attorney. There's always something we can do to get it to the closing table, but we want to make sure it's closing on time. And again, no unexpected issues or questions are coming up at the closing table. Now, I kind of threw a lot of information at you. So again, I'm going to give you a copy of these slides and also opening up for questions now. This is my cell phone number. Please reach out. It's probably the best way to get a hold of us. I encourage you to call. We love hearing from you guys. We love helping you guys. You'll see my email address there as well. We also have an agent attorney hotline. So if you guys are writing an addendum, putting some sort of contingency in your contract and just need help with the verbiage, something like that, you may always give us a call that way as well. So if you guys have questions, I would be more than happy to address those now. I will also be available afterwards, so you can reach out to me via email or give me a call and we can talk through, if you have any certain challenges or issues that you're dealing with currently as well.
Wonderful information. So informative. Thank you, Joanna. And I can read the questions to you as they come in. We have one question here. Can you explain the best way to discuss owner's insurance to buyers and provide a quote initially to resolve?
Yeah, so I think the question is regarding title insurance. And you can always point them in our direction. We can talk them through what title insurance is, what it covers, and what it does not. Title insurance is based off of the purchase price of the property, so we can always get you a quote on the front end of things as long as you know the purchase price. There is lots of information out there regarding title insurance, and again, we are happy to sit down with your client, one, to address what it covers and what it does not, and why we encourage all clients to have that. Some of the issues that come up during the title work, title insurance may be a very important aspect of that issue. So, we can talk them through what that means practically for them in the long run if they're choosing to insure over an issue, or perhaps that issue is being accepted from their policy. So again, you can point them in our direction. We can always get them quotes. That's an easy thing to pull. And hopefully that answers your question.
Great. Thank you so much. We have another question. Can an HOA actually control what a homeowner does inside their home? i.e., how many cats can be in this house? How is this enforced?
Great question. My kitties also think that's a great question. Yes, essentially. Covenants and restrictions can do just about whatever they want as long as it is not illegal. Practically speaking, do we see HOAs enforce, animal restrictions inside of the house? Typically, no. But yes, they may have the authority to control that as well. So covenants and restrictions can be really important to identify and read through prior to closing, prior to signing that contract. Now, again, they cannot do anything illegal, so there can't be any discriminatory language, anything like that. But absent that, covenants and restrictions can do just about whatever they want.
Once recorded, are C&Rs good forever?
That will depend on the language in the covenants and restrictions. Most of them are indefinite. They will run with the land until they are amended or completely taken away by the owners. But that language will be in the actual document itself. Sometimes we do have covenants and restrictions from the 50s that only run 20 years, so those are no longer applicable. But that information again is going to be shown right in the document. So sometimes you will find some that are expired. Most times those will just run continuously.
Great. And last question, does a title search only cover 40 years?
Now, statutorily, we search back 40 years because most of real estate claims have a statute of limitations for 30 years. So that's why you see that key number of 40. But most often, when we are searching back 40 years, depending on how long an owner has held the property, or if we have a more complicated title search and just need some more information, most often it's going way back, more than 40 years. Now, commercial property will go back 60 years. But, if we go back 40 years and say that owner at the time owned the property for 30 years, then, we're actually going back 70 years. So most often it's more than 40 years. But the reason, again, we cap it at 40 is because of that statute of limitation. Most claims for any type of real estate litigation, the longest one is about 30 years.
Great. Well, thank you so much for some amazing and helpful information. I think that was everything in terms of questions, and we so appreciate you being here today and for your time and expertise.
Thanks for having me, guys.
Thanks, Joanna. So thanks for the questions. Thanks, Joanna. Speaking of insurance, which you brought up insurance, we have Chris Hayes on the call this morning. We're very proud of our partnership with Caine Hayes. Chris is going to walk us through a new offering, which he's come across, which has been very helpful to agents. And so, Chris, will you kind of take us through that this morning?
Sure. Thanks for having me on virtually today. That was great information from Joanna, and we hope what we offer here will be helpful and informative. You guys are doing a great job of sending the referrals over on the personal line side, trusting your clients with us. And we want to be here for you as well. So as Stephen mentioned, there's a product that I really think each of you needs. We can tailor it to your needs specifically, but we can move forward to the next slide. Caine has done a great job of purchasing insurance to cover them and you, but there are some holes that fall in that there's just no way to get a group policy for. So you as a realtor, these are issues that come up every day in our market. You've got the first example, your client is in a home, they knock over a $15,000 antique vase. Your client uses a toilet, it overflows, maybe they're in an electrical panel and somehow an ice maker malfunctions and a hardwood floor is ruined. These issues come up a lot, and there is really, in some circumstances, no coverage. Most homeowners don't know that they have to schedule high value items on their homeowner's policy. So that antique vase or piece of artwork that your client has damaged is not going to be covered, and they're going to come to you. The potential buyer is injured during a showing. So they're in the attic, they fall through, they've done damage to the person's property, and they're injured. That is an opportunity for you to be sued personally, unfortunately. Someone gets into your computer or phone, and that database that you have that is so valuable to you is taken, completely ruined. Earnest money or actual down payment on a home. So misdirected wire fraud. Misdirected payments is a very hot button item in the industry over the last 5 years. We see that has really grown, and we've had some instances, I believe here in our Greenville market. We have a way to help you, even if Caine's email system was not hacked into. And I know a lot of you are showing homes before they're officially on the market. You're in the home yourself. Maybe you do damage to the home. You could be liable in that situation. We can move forward to the next slide. So we always try to go out and find the best option for each of our clients. And Allstate, friend and colleague of mine, Brad Hughes, has brought this to our attention. They have a Realtor BOP, business owner policy, that is catered directly to you, and I feel like it's going to meet the needs of each of you as Caine agents. It is like a homeowner's policy in that it's a package that we can cater to your needs. There is your general liability if someone is injured and were to sue you individually. There is building protection for your home office, your personal property, your computer. But one thing that's really neat with this package is they extend that business personal property, and it will go to cover property damaged at a showing or an open house, which there's not a lot of, we couldn't actually find another product that would guarantee that. So we're very excited to offer that with this package. And you also can add the Cyber Suite endorsement, which I would highly recommend. They will do $25,000 all the way up to $1 million. And depending on your production level, we can talk with you about what makes the most sense for you. We can move to the next list. Thanks. So in that Cyber Suite, we've got your data compromised. They're in and your database is compromised. Your computer's attacked. The network security, the misdirected payment fraud. So that is the situation that we're seeing. There is an email circle or a chain that you're on, the client's on, the closing attorney, the insurance person, the mortgage broker, we're all there. Say someone hacks into someone else's email system. They then mask spoof someone's email address, and they ask the client to send money the day before a closing. Say $50,000 is sent. In a lot of situations, even if Caine's system was not hacked, you did nothing wrong. If it was your email address that asked the client to do it, we all know that there's so many attorneys out there. There's still more attorneys in law school than they are active attorneys in our country, and they're great, but it's a very litigious society. And we all understand that you most likely would be included in a lawsuit in that situation. The cyber suite covers identity theft recovery, extortion, fraud, and media liability as well. So if we could move to the next slide, this will show you what a package would look like, something that I would recommend for one of Caine's average agents. We've got $1 million in liability to cover you if someone was injured and were to sue you. We've got that business personal property that's going to cover your property and the property that is damaged while at a showing or open house. And with a $500 deductible, that's only $365 a year. We can add that cyber suite coverage, which I think is going to be very important for you at a $50,000 level. And with a $1,000 deductible, that's $360 a year. So we're at $60 a month to get you covered for some situations that I think we can all agree are highly likely to happen in your career. One of these. We can move that cyber suite. I'm looking at one for Virginia, and we're looking at maybe $250,000 for cyber suite coverage for her, and that would only go up to about $120 a month. So this is something that I feel like each of you need. We can, like I said, tailor it directly to each of your needs. We've got just a little fact sheet that's very brief that I can email to you. There's going to be a brochure in each of your boxes as well. And this is something I'd like for you to contact me directly. You can call the office, 551-4267, or probably what would be best is just to email me directly, chris@cainehayes.com, chris@cainehayes.com. And this, like I said, is very quick. We can get this turned around in probably a day. And I really feel like it's something that each of you need. And I'm happy to answer any questions you have on it. And thanks for your time today.
Thanks, Chris. We appreciate it. And, I will remind each of you, you're running your own business, right? And it is an extraordinarily litigious society that we're in right now. Emotions are extraordinarily high in this marketplace, right? And there's a lot of hurt feelings. And so as a business owner, we encourage you at what is a very reasonable rate to have some type of insurance to back you up. Chris will confirm this because all of our company insurances with Caine Hayes, tens of thousands into the six figures, really, the insurance policies that we have. Right? And they cover you, our E&O insurance covers you and so forth. But a simple reminder, some of the wire fraud issues we're seeing, as we said, in this case, all the evidence and conversations we have, an agent on the other side of the transaction was hacked, which led to our client losing money. And think about it from a pure errors and omissions standpoint. Coldwell Banker Caine did not make an error or omission in that specific situation. And so our E&O is not necessarily going to pick that up. That's not to say we don't have other policies in place that we would try to file a claim against should that be the case. But it's a very litigious society. It's very tricky. And this is a very unique product that is designed specifically for real estate agents. So we would encourage you to consider that. So on with the announcements. We're really excited that we have Gin Blue coming up later this month in October 4th through the 7th. Registration opens on June the 22nd. So one thing to notice about Gin Blue this year, as the world starts to open back up, Coldwell Banker cannot tell us, even though registration opens on June 22nd, they cannot tell us if there is going to be a cap on the number of attendees who can attend live. A lot of that is because they're working with the city of New York to try to understand what type of restrictions or requirements will be in place in October. And so if you recall, several years in the past, Gin Blue registrations have sold out very quickly. So we want to start the conversation with you now. We're going to have a great group from Coldwell Banker Caine in attendance. It'll be a great time in New York City. We're going to do a lot of fun stuff together. And there'll also be some great educational opportunities. A lot of it's going to be hosted in Radio City Music Hall. So we hope you can join us. If you'd move forward, Elizabeth, please. So I do want to recognize on the next slide are our $10 million plus producers who qualified for our free registration to Gen Blue this year. This was part of Caine College that we announced several years ago, making an investment in you. And Kirsten Bell, Stephanie Berger, Tracy Capio, Helen Haygood, Virginia Hayes, Brian Hurry, Kim Johnson, Francie Little, Jacob Mann, Donna Morrow, Heidi Putnam, Kimber Roberts, David Seaver, Jennifer Sims, Andy Turner, and Jennifer Wilson have all qualified that for our Gen Blue registration. And so we're really excited to provide that to you guys as part of Caine College, and we appreciate all that you're bringing to the Caine family. More information is coming. I know Jane Harrison has sent these folks an email, and we're starting the process. So we hope you will make that investment in your business and yourself, and join us for a great event in New York City in October. On Thursday, June the 17th, we bring back the summer socials. And so we're really excited at both 111 and in Spartanburg. We'll have a food truck lunch. And I know Amanda and I and the entire team has received great feedback over some of the events that we've had over the last few weeks. And it's really great just to get everybody back together. And so we're really excited to see you. So join us at the offices on those days, have lunch with your colleagues, and we look forward to being with you on June the 17th. Myself and the leadership team, Milt meets with us in the alternate months that he doesn't meet with the entire company. And he had such a great inspirational message yesterday about self-care and taking care of ourselves. And so we want to congratulate our Thrive Challenge winner for the first half of the year, Jennifer Wilson. Congratulations, Jennifer, for participating and getting at least 30 minutes of activity in on 39 of 61 days. We're proud of you, and we just appreciate all of you who engage in this program. We believe in it very, very passionately. And in this stressful sort of time, I think it's really, really important to remind ourselves to take care of ourselves. And if we take care of ourselves, it's a whole lot easier to take care of our families and our clients. And so congratulations, Jennifer. You will be receiving a $150 Lululemon gift card. And then finally this morning, Amanda, do you want to take us through the training calendar for the month of June?
Absolutely. So we have some great classes lined up for the next few weeks. So later this week, we have Moxie Present with Allison, and that's Thursday from 10 to 12. If you haven't learned that tool, it's just, we've had wonderful feedback, and we would encourage you to join us for that. And then obviously with relocation, if you are competing for listings as part of your relo business, we have a great two-part session or two sessions planned for you. And this is really just to help you be able to know when you're competing, certain things to present and how to best align yourself to win that business. So we encourage anyone that's in relocation to join us either Wednesday, June 23rd or Tuesday, June 29th, depending on which location you're at for those sessions. If you don't currently do relocation business or you're not yet eligible, you can still join these sessions. They're open company-wide. So we hope that you will refine those listing skills and join us for these classes. And then the habitat build, we're so excited about these opportunities through Caine Cares. If you've not done this before, I did it several years ago, and it's just such a fulfilling project, and you get to be around some of your Caine friends. So the first build is Thursday, June 10th. We still have a couple openings for that. So if you're interested, please let us know. We also have a second build on Wednesday, August 3rd from 12 to 3:30. So we hope you will be able to join us for one of those sessions.
Yeah, thanks, Amanda. And as a reminder on that, those habitat builds, this is part of the CEO habitat build program. So I'm participating in that. David Lominack with TD Bank is leading that effort. And so Caine is one of 32 companies that's participating in that program this year. So the build that's coming up on Thursday, we do have a couple more spots. And as we were talking about Brad Halter and his big anniversary and how long he's worked for the company, prior to it started, Brad is the only man who is signed up for Thursday's build. So I know he is starving for some muscle to join him. So guys, let's step up and help in the Thursday build. I will be on the August 3rd build and look forward to seeing that you all there. So, hey, thanks for another great Caine Live. Chris, thank you very much. Joanna, thank you for your partnership and guiding us through today's presentation. Y'all are doing a fantastic job. We appreciate all that you're doing, and we will talk to you soon. Have a great week.